I'm really excited to talk to you about something that I'm passionate about, which is access and privacy. So my goal for this evening is to provide each of you with information about how you can access information that is held by Alberta public bodies, such as the town of Turner Valley or other provincial government agencies. Please feel free to stop me as we go through the presentation, as I want this to be as interactive as possible to ensure that you get the most out of this session. I'm actually going to throw this here down, Todd. Perfect. So just briefly, what we're going to talk about tonight. So who is covered by the FOIP legislation? So we're going to walk through the agencies, the public bodies. So when you hear me talk about public bodies, that's who I'm referring to. I'm talking about the municipalities, your police services, your provincial government agencies, all of those. So we'll walk through all of that. Then we're going to talk about the 5 fundamental principles that are spelled out in the FOIP legislation. So this is really, why does this legislation exist? What is the purpose behind it, and what is it seeking to achieve? Then I want to walk through the access process with you so that you understand how can you, as residents and perhaps council, access information that is held by the public body. Then we're going to walk through the exceptions. So there are a number of exceptions in the legislation that actually make it possible for a public body to withhold certain information, but those exceptions are very specific and limited, and they should be really used in situations where there's the potential for harm that would be resulting from releasing such information. Then I'm going to talk about sort of how does the granting of access to information happen. We'll move into then, so let's say that the public body releases information, maybe you get that information and you're not satisfied that that's all of the information that the public body holds. There is a course that you can take through the Office of the Information and Privacy Commissioner, and what they will do is actually open a review and review all of the, how the public body made the decision, how the information was reviewed, redacted, all of that, and so we'll walk a little bit through that process as well. I also want to take this opportunity, just because we do have some councillors in the room, to talk about what are your obligations under the legislation. So we can talk about that as well. Also, because there have been a number of in-camera sessions, and I do get this question quite frequently, what is the authority for council to go in camera? So we'll talk about that because it's very linked to the Freedom of Information and Protection of Privacy Act. We'll also move into then some best practice considerations for council and potentially its administration to think about. Then I have a few resources, and then we'll move into questions. All right? I guess one other thing I want to say is that this session's not meant to be exhaustive of all FOIP issues. There are other issues in terms of correcting personal information and all kinds of things, but this is really meant to talk about the access piece tonight. Okay, so moving into who's covered by FOIP. So as I already mentioned, provincial government agencies are covered under FOIP. Healthcare bodies, they're also covered under the Health Information Act. So what specifically is covered under FOIP is personal information. And when I say personal information, I mean your name, your address, your phone number, your email address, any identifiers that you may have. It goes so far as to actually be if you have a specific tattoo, that is your personal information. So it's a lot more than simply just information on a page. It's pictures, it's a whole host of information. FOIP also extends to educational bodies, so universities, school boards, and technical institutes. So, and then mostly why we're here tonight is to talk about local government bodies. So now we're talking about your municipalities, your municipal boards, committees, commissions, all of those are subject to FOIP. Housing management bodies, so the one that's prominent in this region is Westwind, so they're also subject to FOIP. Policing committees and library boards are also have to follow the FOIP legislation, and then police in general. There are certain records that cannot be accessed utilizing FOIP, such as court records, teaching materials, land titles, personal property, motor vehicle records, constituency records. So correspondence that you have with constituents is actually not subject to FOIP. That being said, well, the second you turn it over to administration, it does become subject to FOIP. So I would be very lenient and cautious about how you do that. And then health information and more. So then moving into the 5 fundamental principles. So one of the key things is that FOIP does is allows any person, and I'm saying any person, you don't have to be a resident, you don't have to be on council, you don't have to, any person has a right of access to records that are in the custody and control of a public body. And so what do I mean by custody and control? That doesn't mean that you have to just physically have possession. So if you, let's say, contract out your IT services, those records that are with your IT provider are still subject to FOIP and are still classified as being under your custody and control. So you are responsible for those. The other thing, to control a manner in which the public body may collect personal information from individuals, to control the use of that information, and to control the disclosure of personal information. It also is to allow individuals subject, like I said, to specific exceptions, a right of access to personal information about themselves held by a public body. So, for instance, if I wanted to access my information about the property that I own in the town of Turner Valley, that is my right, pursuant to FOIP, to contact the town and ask for that information. We'll talk about how that would happen and sort of the process around that, but that is a right that each one of us has. It also to allow individuals a right, to request corrections to personal information about themselves. So let's say I go forward and I ask for access to my information that the town of Turner Valley has, and I don't think that something's right. Maybe they have something as minor as a wrong email address. I have the right to request that they correct it, and they have a certain period of time to do that. The Act also provides for independent reviews of decisions that are made by public bodies, so that is primarily the Office of the Information and Privacy Commissioner. Also, with changes that have come in force with regards to the Municipal Government Act, a person now may also request a review by the Alberta Ombudsman if they're not satisfied with the process followed by the municipality or the Office of the Information and Privacy Commissioner. So, in terms of an access process, so what happens is that somebody contacts the public body who they think has those records that they're looking for, and they provide a written request. And in that written request, they have to include specific details to the public body about what they are looking for. In terms of sufficient details, let's say somebody gives a really broad explanation of what they're looking for. And the public body says, I don't understand what information, what records are you looking for? That doesn't mean that the public body can just dismiss it. They actually have a duty to assist the applicant. So it's the public body's responsibility to go back to the applicant and say, we want to work with you. How do we clarify your request? What exactly are you looking for? You say you're looking for contractual information about X. Well, are you looking for the agreement? Are you looking for the correspondence? What are you looking for? And to help work with them to get them the information that they're looking for. Also, on a subject of custody and control, another point you'll want to keep in mind is that it actually extends to your contractors and service providers. So as I mentioned about IT, the same goes if you hire a consultant, or they still have to be bound by the same responsibilities. And even though you've released that information to them, the town or the government agency is ultimately responsible for what happens with that information. And so you may want to consider putting provisions in agreements and things with those providers to protect that information. The legislation also requires public bodies to create records that are in electronic format, utilizing normal software. So let's say you have all of your assessment information or your financial information in some sort of a software program. That doesn't mean that you don't have to release that. You have a duty to somehow find a way to put that into some sort of usable format, and that's the key. It has to be usable. So if that means you have to put it into Excel and manipulate it a little bit to make it usable for the user, that's actually a requirement of the public body. So typically, once the public body gets a written request, and so the forms I've actually handed out to you is typically what you would see on municipalities and government agencies' website, that is typically the form that we ask for people to fill out when they're looking for information. So what happens is you have that form, you submit it into the town or the province or whoever, along with the fee, which we'll talk about in a little bit, and then the public body has 30 days to respond. That 30-day period may extend if the applicant doesn't provide sufficient information. So going back to if you have to actually clarify the request with the applicant, then you may have the ability to extend that time period, but it's only for another 30 days and nothing beyond that. A public body can also extend its time limit for responding if the records that it's dealing with are voluminous. So I'm going to use something from my personal experience. Is we had a number of FOIP requests for flood information following the 2013 floods. You can imagine the amount of paper and things that needed to be looked at in order to respond to these access requests. So those ones fell into that voluminous category. The other thing that you can extend the time limit for responding is for third-party consultation. So if somebody is asking for information about another person, a business, anything like that, the public body has a duty to consult those people. So they have a duty to reach out to them and say, do you meet certain criteria to actually withhold that information? It's not for the public body to decide that there's no harm and just release it. So that would also allow you to extend the time limit. So when I talk about fees, there is a $25 fee for non-personal information. So when I say that, I'm talking about the flood records. So the flood records typically weren't about personal information. If somebody did contact and say, I want the flood records specific to my house, that's different. But this was generally about, I want to know how the flood was managed at a higher level, or copies of certain studies or reports or correspondence. That all falls into that $25 initial fee. You can also charge a $50 fee for non-personal information where it's a continuing request. So let's say that I have submitted a request to the town of Turner Valley for a certain piece of information, and I've said, you know what, in a year from now, I want you to refill my request. I want to know if there's anything else that's come again that's relevant to this request at that time. So that would be a $50 fee. So it depends on sort of the nature of the request, what fee gets applied. With regards to personal information, so again, going back to if I want to ask the town for my information, the initial fee is free. So they cannot charge me any dollars for me to access my own information.